So we need to talk about a recent 9-0 unanimous decision issued by the Supreme Court involving the Fourth Amendment's protections against unconstitutional searches and seizures, and then also excessive force by law enforcement officers and how that type of activity impacts your rights. So let's talk about what happened in this critical ruling and what is happening now in this case. Now, before we jump into this video, I want to thank the sponsor of this video, which is Silent. Now, let's face it, we all know that our phones and other electronic devices like laptops are actually just tracking devices. Big tech, government agencies, and even cyber criminals, they're all collecting our data, and they're doing that through some of our devices. That's why it's always a good option to maybe look into, Faraday bags and other options, and I highly recommend Silent. Their Faraday gear and these bags and other items you can get block all wireless signals, cellular, Wi-Fi, Bluetooth, GPS, and a lot of other signals that, government agencies, hackers, all these people use to get into your devices. I use their backpack every single day when I'm going to and from the office. I put my laptop in there, my phone in there, and then also I use it a lot when I'm going through airports or when I'm staying at hotels because, again, I want to protect those devices and I don't want people to get access to my devices, to my phone, or to my laptop. So again, if you're interested, you can protect your privacy, your freedom, and all of your family and your devices by just simply using a Faraday bag. I highly recommend Silent. You can go to silent.com/scholar and you can get 15% off and a free shipping as well on these products. Again, simply just go to slnt.com/scholar. And again, I will link that all down below in the details section and also in the pinned comment. As I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 unanimous ruling by the Supreme Court. And this case involves the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force actually impact that right. This new unanimous ruling by the Supreme Court came in a case called Barnes versus Felix. This new lawsuit should be on everyone's minds, especially gun owners, because it involves, when courts need to look at the totality of the circumstances and how they need to analyze these situations going forward. Although this case is not a traditional warrantless search and seizure case that we've talked about in the past or a Second Amendment case, the Barnes case does directly address the whole seizure doctrine and potentially how excessive force by law enforcement needs to be reviewed and analyzed under the Fourth Amendment. As gun owners, we've seen a lot of highly publicized situations where law enforcement interact with lawful gun owners, and through excessive force, the gun owner ends up getting shot or something, fatally happens where there's someone's fatally wounded. And there was also a lot of discussion during oral arguments about the Second Amendment and when law enforcement don't identify themselves as law enforcement, they pull a firearm and then someone acts in self-defense. There was a lot of discussion about that as well. So this impacts a broad kind of range of situations involving law enforcement and excessive force. Now, the facts surrounding this case are as follows. The individual here, Roberto Felix, who is the law enforcement officer, pulled over another individual named Ashton Barnes for suspected toll violations. So the reason for the stop was toll violations, and there were cameras along this Texas freeway, and the cameras identified that this individual had toll violations, so that's why he was pulled over. Officer Felix ordered Barnes to exit his vehicle, and Barnes opened his door and acted like he was going to exit the car, but then he attempted to drive away. Reacting in a split second, the officer there, Officer Felix, decided to jump on the kind of floorboard of the open door. So he kind of jumped on the ledge of the car as it was driving away. And then in a split second, kind of in 2-second time frame, he shot 2 shots at Barnes as the car was moving away. Barnes was fatally hit, but he did manage to stop the car, even put it in park. And in the totality of this whole situation, it was about 5 seconds in total, which kind of lapsed in times between when the door was open, he began to drive away, and when the whole shooting happened and when the car was stopped. So about 5 seconds in total. In response to this incident, Barnes' mother and his father sued the officer for alleged violations of Barnes' Fourth Amendment right against excessive force. Now, the district court on review granted summary judgment to the officer, applying the Fifth Circuit's moment of threat rule. The Court of Appeals took this up on review and then eventually affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. Now, under that rule, the events leading up to the shooting are essentially not relevant at all and do not need to be considered. They found that here the precise moment of threat was the 2 seconds when the officer was clinging to the moving car as Barnes attempted to escape. And because Officer Felix could then have reasonably believed that his life was in danger while he was on the moving car, the Fifth Circuit panel held that the shooting was lawful. This case eventually made its way to the United States Supreme Court, and the question the Supreme Court had to answer in this case was whether the courts should apply the moment of threat doctrine as the Fifth Circuit applied, or something else when evaluating these types of Fourth Amendment claims. On review, the unanimous Supreme Court held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of the officer force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the limited moment of threat analysis that was used by the Fifth Circuit, and instead they applied kind of a totality of the circumstances approach, which is interesting because even when this was making its way to the Supreme Court, the arguments that were made by both sides, even the sides made by the state of Texas and that side, they were even moving away from the moment of threat analysis that the Fifth Circuit applied. They were also kind of moving the goalposts and saying that yes, something more needs to be looked at. Now, they concluded by pointing out that the court does not address a separate question about whether and how an officer's own conduct, can create a dangerous situation, which factors into that whole reasonableness analysis. That was one of the things that was argued heavily during the oral arguments by both sides. Both sides were kind of in agreement that the Supreme Court here could issue a more limited and narrowed opinion just mainly on the whole moment of threat and totality of the circumstances, but they did not need to get into looking at the police officer's conduct and how a police officer engages in certain conduct that creates an unreasonable situation where there is no option other than lethal force, but because of that they're the ones that cause that situation. So the main thrust of the decision was rejecting the more limited scope of analysis applied by the moment of threat review by the Fifth Circuit. Instead, the Supreme Court orders lower courts to look at the totality of the circumstances before, during, and after the incident and kind of create a more comprehensive picture of whether or not the Fourth Amendment is actually violated. Now, like I mentioned, there was a lot of discussion during the oral arguments and even in the concurrence, which was authored by Kavanaugh and then joined by Thomas, Barrett, and Alito. There was a lot of discussion about the dangers of the job that police officers do and these kind of situations that they find themselves in. The concurring opinion really focused on pointing out how dangerous traffic stops really are for police officers and how they're at greater risks during these types of stops and how there's a lot of fatalities because of these types of traffic stops. The justices in the concurrence also pointed out how when a driver pulls away, like Barnes did here in this situation, officers don't have a lot of great options. There are options, but it's not a great situation for police officers, and there's a lot of major threats to their safety and then also to the public safety as well. Now, like I mentioned, during the oral arguments, the Supreme Court was concerned about cases like police officers failing to identify themselves and someone exercising their Second Amendment rights and the right to self-defense because a unidentified police officer walks up to them and maybe has a weapon drawn. Limiting those reviews to the moment of threat analysis overrides other fundamental rights, and that is something they were concerned about. Now, they did not directly rule on that, but it was a concern of the court, and it is something that can be reviewed by the lower court if those types of arguments are raised. So in essence, the Supreme Court found that courts must look beyond just the moment of threat and instead look at the totality of the situation. And that means that the Fifth Circuit and the District Court here are going to have to look at, the reason for the stop based on toll violations, the interaction that the police officer had with Ashton Barnes, the decision that the police officer made to jump onto the vehicle, and then all of those situations after. So they're going to have to look at the totality of the circumstances. The Supreme Court, because of that ruling, has now issued their mandate, sending this case back down to the lower court. Now, one wrinkle to this that I wanted to point out is this case is now being opened back up in the lower court, but it's also being argued by the mother and the father. And the father, I believe, is kind of representing himself pro se. I believe he's also potentially in prison. And so I see some filings where he's, arguing on behalf of the son based on the new Supreme Court arguments. He's doing that pro se, and I believe he's in prison. So it's going to be interesting to see how this develops, because of some of the arguments that are being made, but it appears that the case is now being opened back up by the district court. There's arguments that litigation needs to be, argued once again in light of what the Supreme Court said because of that new Supreme Court ruling and the mandate. Now, this case is important because it impacts everyone's Fourth Amendment protections against excessive force in these types of situations. For gun owners, like was expressed by the Supreme Court during the oral arguments, there's a lot of situations where you have interactions with police officers where they engage in conduct that, threatens you, puts you in bad situations where individuals, are potentially shot by police officers. Police officers don't identify themselves. And in those types of situations, if law enforcement overreacts, misjudges, or does something improper to a lawful gun owner, the totality of the circumstances test now gives courts more leeway to rule in favor of the citizen and the individual over the law enforcement officer. So this is a critical decision that I wanted to bring to your guys' attention, more nuance about what's going on with this ruling and now how it's going to play out at the lower court now that it's opened up based on what the Supreme Court just said in their new ruling. So if you guys like this video and you like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armedscholar.com. Over there on the website, we have the free legal guide that you can sign up for. It's free to do. All you have to do is put in your email, and then we will email you over a PDF, and we also do some follow-up email with additional free education. And then you can also check out the website for other things that we have on there as well. But as always, thank you guys so much for all of your support. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.